Okay, good morning or good afternoon, everyone, depending on where you are, and welcome to today's webinar. Now, for those who are new to this, my name is Joel Comerford. I am a consultant here at Lawpath, and I'm also your host. Now, before we dive into today's webinar, can I get the vibe of how everyone's feeling today? Can I get some good or some bads in the chat box? Let's um let's determine everyone's disposition today. Is everyone excited? Wonderful. Oh, this is great. Everyone's having a good day so far. That's good. Look, I'm not going to judge you if you have a if you are having a bad day. Margaret, I'm not sure where you are. We're in Sydney, as everyone knows. It's freezing, absolutely dreadful. 4 a.m. in Johannesburg. Oh, Nicole, welcome, welcome. Wonderful. All right, guys. So for those, as I mentioned, well, I'll bring it up again. If you are new to Lawpath, if you've been recommended to come by and check this out, or if it's your first time, we've been around for 10 years. We are an online legal and accounting platform. And in that 10 years, we have served over 500,000 businesses, which is a strong point of pride for us. And that number is growing every day. So if at any point after the webinar, you do wish to have any kind of business discussion around maybe a potential new investment or just general ideas about how I guess we here at Lawpath can assist your business moving forward and keep you compliant. I will be sending out an email at the end. It'll have all the slides from today, and it will also have this episode. Now, we do upload every single webinar episode to YouTube, so if you do want to catch up on some that you've missed in the past, just type in Lawpath on YouTube and you will go ahead and I guess get every single bit of information that you missed. I think we're up to about 70 or 80 episodes at this point in time, so there's a lot of decent information. Moving forward, today's webinar topic is legal essentials for hiring employees, contracts, awards, and compliance. In this session, we'll be diving into the key legal requirements that every employer needs to know when hiring in Australia. We will have a Q&A at the end as well, but if you guys have some burning questions that you want to throw in throughout the webinar, just go ahead and chuck it in the chat, and I'll do my best to have our speaker address those. Otherwise, if you're happy to wait, the Q&A will be at the end, and we can go and hash out anything that you guys are currently dealing with or you are interested in discussing. Now, who is our presenter? I do know that a lot of people in today's audience will know our presenter, so I'm very delighted that you can have a little bit more time with her. It's a pleasure to introduce Olivia Dalton, or as we know her, Liv. Liv brings over 10 years of legal experience to the table with a background that spans both traditional law firms and the fast-paced startup world. She cut her teeth in litigation, which gave her a solid foundation in navigating complex legal challenges and thinking strategically about risk. Today, she's managing lawyers here at Lawpath, where she specializes in contracts, compliance, and dispute resolution. Liv is a trusted advisor to entrepreneurs and growing businesses, and her deep understanding of both legal hurdles and commercial realities make her an invaluable voice for small business owners. So we are very, very pleased to have her here, and I'm sure we'll have her here again moving forward.
Thank you, Joel. Very kind words, extremely kind.
My pleasure. Now, what will we be covering real quick, guys? Employment Contracts 101, understanding awards and minimum entitlements, employer legal responsibilities, common hiring mistakes to avoid, and then later at the end, we will discuss how Lawpath can assist you moving forward with some of our plans and packages. I do believe that's everything. Everyone's happy. We know who's speaking. I do believe it's time to take it away, Liv.
Thank you, Joel. Very happy to be here, and it's great to see some familiar names popping up as attendees. I think I've spoken to some of you on our legal advice calls, so great to see you again. All right, let's get into it. I'm driving today, so as Joel said, please, any questions that you've got, I'm happy to answer them on the go. Just pop them in the chat. Joel and I are together as well, so anything that pops up, we can collaborate on. Happy to make this a very open forum. So yeah, we're here today because you may have employees, or you may be looking at bringing on employees, or you might be thinking down the road, thinking, do you know what? I've got so much as a small business owner on my own plate. Maybe I need some help. So that's great that you're here today, because these types of conversations are very important to have. Alrighty, so I might get into employment contracts 101. Alrighty, so employment contracts. Do you mind just reading that? Sorry. Okay, so we've got a variety of different ways to employ people. I think people, everyone's had a casual job here and there in their life. So certainly casual employment is probably all something that we're quite familiar with. Part-time is something that we also often employ people in, and full-time is probably the most common form of employment that we've got here in Australia. Now, more than happy to have a separate conversation and discussion on contractors, but today we're going to focus and zero in on employment contracts, because there's and a lot changes year to year. There's a lot dependent on changes to the awards or the industries that you're in. So we'll dive into that today and keep it really specific to employment. But yeah, of course, let's always have a conversation if you're not sure whether a contract is the right move for you at this point in your journey, or whether you're ready to go straight into employment. So in terms of things to include in your contracts, certainly job title and duties. Now, one key thing that comes up all the time for us is, people love using Lawpath AI to put together a job title and duties for their new staff members. But one thing that we often don't include is the really specific stuff that we really want our staff to do. So if that part of that job is take the bins out every Monday, really my advice there is to always include the level of specificity that you need from that employee, because sometimes, not all the time, you get employees that really take that, list of duties very seriously, and they won't want to do anything outside it. So, if push came to shove and that employee wasn't necessarily working out, you'd want to be able to point to the contract and say, do you know what, these X, Y, and Z duties that we've listed out for you, you're not doing, or you're refusing to do. The other key decision to make is defining the nature of the employment. So casual, often a really easy initial step to take if you're looking to bring on an employee, because you're not sure how much you're going to need them. You might be using them ad hoc, and there is no guaranteed employment on an ongoing basis for them. Now, there is an obligation, which we'll talk about later, about converting that casual employee to part-time or full-time if there's a bit of a systematic period of employment. We'll get into that later, but it's always something to keep in mind. You always need to list out the pay, the benefits, and whether it's inclusive or exclusive of superannuation. No way out of paying someone super if they're an employee of yours. Leave entitlements. Now, the National Employment Standards are a really good resource here for you to go back to understand exactly what you are required to give in terms of leave. And we are always here to double check those things for you if you ever want to have a quick conversation with the lawyers about, if you're not sure, is it 4 weeks? Is it, 2 days compassionate leave, or does this accrue? Those types of questions we're here to answer. Now, a lot of you are starting small businesses. Often what we see is a lot in that tech space, a lot in the AI space. And one of the key parts for you is your confidentiality and your IP, because your business might not have a bricks and mortar shop. Your business might not have a specific product that you sell. Your business really is your IP. So therefore, you don't want your IP walking out the door if somebody leaves your business. So that type of contractual obligation needs to be really watertight. Now, the other thing is, with something that we always don't want to think about, but it often happens, and it always is front of mind for us here at Lawpath, is the termination and probation provisions, because that really gives you, as the employer, some leverage and some power to be able to move people on if they're not quite working out for you. So those notice periods you can always be really specific about. I'm just looking, Scott's got a question. Could a catch-all phrase like any other duty as directed by the employer cover any shortcomings in the job description? Scott, have we spoken before? Because that's something that I like to always include. But what I also do recommend there is adding in writing. So you do want that sort of stuff listed down in writing so you can point back to it and say, hey, on the 7th of March 2024, I asked you to start taking the bins out and you didn't do it. I hope that answers your question. We'll go on to the next one. I probably need to move a bit quicker. So I think we're all here for a reason. We all understand that there are risks bringing on employees. But I think the reason why you want to be really clear with your contracts is so you can feel confident that all of your employees are very clear about what they need to do, but also you're preventing and planning for when things are going to go wrong. And you could be the best employer in the world, but these things do happen. There's a lot that we can't control in this world. So these types of contracts are worth spending the time, effort, and money on. In terms of that tip down the bottom, really tailoring it per role. And there's some little ways and tricks of the trade that us lawyers like to help you create tailored contracts as well, rather than just pumping out the same contract for every single person. You might have a data analyst and a salesperson that shouldn't be on the same contract. But there are ways that we can tailor it so you're spending less time preparing your contracts, more time earning money for your business. Alrighty, so I might just leave this one as is. As Joel mentioned, you will get a list of the slides and a copy of the slides at the end of today's presentation. But these are the key clauses that I think really, at a bare minimum, should be included in your contracts. Okay, so in terms of awards and minimum entitlements, now this is something that you may have heard of. Or this is maybe something that you're really aware of. We've probably seen clients in all areas of that spectrum. So, and that's okay. We're here to help because awards are really, really hard. And you guys might see in the news often, a big supermarket or something like that have the best lawyers and and the best in-house legal team in the world, they still get their hourly rates wrong, and that applies to an entire supermarket worth of employees across Australia. So these things are really hard, and that's why we're here to help, because the awards are very, very detailed. They're prepared by members of parliament who don't necessarily have employees day to day. So actually applying them to real life is the tricky part. So, asking somebody to work on a Saturday, for example, when they've got a Monday to Friday job, how do you navigate that with the award? Those types of questions are really tricky ones, and they catch everyone out. So each award really is its own specific award, and understanding one award, so you might be really familiar with the Clerk's Award. That doesn't mean that you're necessarily familiar with the engineering and welding award, which I think I've meshed two together there. But there's very specific awards with very specific requirements. So awards set out things like penalty rates. So just talking about the engineering one, for example, I had a client the other day who, when things are more dangerous, they have to pay a higher penalty, or if they're working later at night, they have to pay a higher penalty, those types of things, and trying to navigate how that works in a regular workplace. Also, how the hell do you do a payroll for that? Because, we're asking each person to do very specific things. So those types of things are covered in the award in quite a lot of detail, that sets out overtime, allowances, and their hours of work. Now, that's often a common misunderstanding, that every single person is required to work 38 hours of work. But each award is actually really specific about how much a minimum or a maximum that a person can work per week or per month. So something really important to pay attention to. And as I mentioned before, so the national employment standards, there's minimum entitlements. They're things like sick leave, things like that, personal and carers leave, and you can't override those. They exist in Australia because we're a very fair place to be an employee. So they're things that are really important to be aware of. At the end of every contract, you should be providing them a copy of a Fair Work statement that's also got the link to the NES. And all of our contracts on Lawpath have that little prompt there to keep you accountable to remember to attach that Fair Work information statement. I'll keep zooming along. So yeah, I probably mentioned these already, but in terms of the gaps, so you want to make sure that they're always up to date. So something I always recommend to my clients is diarising something in your calendar that annually or biannually you're double checking that your pay rates and your award entitlements and things like that marry up to what the Fair Work changes are. Especially if you've got employees that have been working with you for a couple of years. You do really want to make sure, the minimum wage goes up every year. Most of those awards are updated, once a year or once every couple of years. So you do want to make sure that if you're paying in excess of the award, for example, that you're continuing to pay in excess. Or if you are getting closer to the minimum wage, why, and understanding why you are, and having a chat to a lawyer to sort of say, hey, is this a good decision to make, or should I, pay a bit more to account for X, Y, Z? So, a really helpful tip as a preliminary step is Fair Work has an award finder tool. So you can punch in exactly what role you're looking for. My tip is, I guess, be a bit general about it. So, if they are a salesperson selling technology, it's probably not going to get that specific for you, but a salesperson, and there's different variations of salesperson on there that will pop up as suggestions. That's probably the best way to use the award finder. And as I mentioned, the lawyers are here to help if you need a hand looking through the award finder. Okay, so as employers, you do have some legal responsibilities bringing on employees that you wouldn't otherwise have, but they're really good things to keep in front of mind. So we've all probably been employees before, or we're aware of somebody else that's an employee, and everyone gets paid and everyone's entitled to super. So this one is a little bit out of date. Superannuation requirement just went up to 12% from 1st of July 2025. So that's always something to pay careful attention to from the date that you're employing the employee. And the good news is for employers, super isn't continuing to go up. At this point in time, they've drawn a line with 12%. So not paying super on time and correctly can attract penalties for you as an employer. The other thing to note is if you're a director of a company and you're employing an employee through that company, you might become personally liable as a director of that company for that unpaid super. That sort of trumps everything else. So super is one of those really important non-avoidable ones. Now, leave management. Now, this is hard. There are tools and really helpful SaaS platforms and things like that that can help you log these because they do really become, one of those admin heavy tasks for you. But I think in order to be compliant, in order to be able to sleep at night, you do need to be able to accurately log all types of leave for your employees. And if they do ask for it, you need to be able to provide it to them in a timely manner. You can't sort of say, oh, I'm just still calculating that. You've got to be onto it. And then, leave accrual. So that will affect part-time and casual people because part-time accrues pro rata and casual, there's no entitlement to annual leave, but there are other entitlements under the NES. So in terms of responsibilities as an employer, everyone has a notice period by and large. So usually you need to have a think about what works for you and your business and whether you want to do the NES a minimum notice period or whether you'd like that to increase. Now, people often do that because of various business needs that they have within their business. So, if it's super hard to replace that particular person, you might want to have a longer notice period. What's an acceptable tracking system for the leaves? Now, there's lots and lots of options. I know that one of my clients yesterday uses Xero. So if you have Xero, thanks, James. But not plugging anything in particular here, but Xero is a really good one. Often payroll, or if you have an accounting contact. Lawpath, certainly, our accountants have varying views on all different platforms, and they're pretty familiar with them. So thank you, James. Any accounting software that does payroll will track the leave. Awesome. Now, I guess in terms of termination, one really hard thing to do is actually let somebody go, because unfair dismissal is a power that an employee has to exercise. So one thing I often tell my clients is it is actually free for somebody to call the Fair Work Ombudsman or the Commission to check whether their dismissal was done lawfully. And because they don't have a job, they have all the time in the world to do it. So the risk is high for people to call and just double check whether everything was done by the book. So therefore, you should have a proper process to roll out every single time you need to let somebody go. So whether they're on a performance management plan, whether you're making them redundant, or whether they've materially breached their contract and we could move straight towards a dismissal, that's definitely something that you should have a chat to a lawyer about before undertaking that step. And in terms of record keeping, as I said, with the leave tracking, pay slips, file declarations, hours of work, and things like that, especially when it comes to casual work, that type of record keeping is really important. And you can't just go and get rid of that information. So 7 years in case there's any sort of audit or dispute. I'll keep going. So there's work health and safety obligations, something that I really recommend putting in policy format. Lawpath has a really handy framework template for an employee handbook that does have that in there, and it's something that oftentimes it's really work dependent, depending on what type of business that you run. So as I said, documenting those HR processes and decisions in writing, and having those policies and procedure in writing are really, really handy. James, is there any situation where an employer can refuse to pay out an employee's unused annual leave upon termination? The answer is, unfortunately, James, sometimes. So I say unfortunately because it really comes down to the situation. You may have heard sometimes that, you can negotiate these things and both parties sign a deed, and the deed would then, alleviate either party from future action or any further ability to exercise rights under that contract. So there are situations that you can do that, but you can't unilaterally. So not one party can decide on that. Both parties need to come to an agreement on that. I hope that answers your question. I'm talking a lot. Oh, cool. I'm speaking a lot. So any other questions, any burning questions at this point, please throw them in. Alrighty, keep going. Alrighty, so pay, superannuation, and overtime. So this has recently changed. So it's great that you're all here and being aware of this. But this information is always available on Fair Work website, and I will say that it's actually a really, really helpful website. It's usually where the lawyers start before they then have to go down various rabbit holes. So it is a really good place to start when you're not sure in terms of the national minimum wage. Now, that is generic minimum wage. That is not modern award specific. So your modern award that your employee might be under might have a higher dollar value. So it's always good to go back to the award. So this number is correct. So the superannuation guarantee has increased to 12% from 1 July. And then there are changes to overtime laws and things like that. Now, we have had webinars and there are some really handy blog posts from Lawpath on things like the right to disconnect, the right to ask somebody to perform reasonable overtime and things like that. So if you're ever unsure, it's a really good place to start because these types of things happen when you run a small business. We understand people just don't clock off at 5. There are still things to do, but navigating that really carefully is tricky. Now, I mentioned this at the top of our presentation, but in terms of having a casual employee that has become a bit sort of part of the wallpaper in your business. So, if I'm starting to work casually on a Monday and Wednesday every week in a factory for you, and I've come to expect that on a Monday and Wednesday I'm coming to work for you, and that's become a bit of a systematic, pattern of employment. The obligation is on the employer to offer casual conversion. So you're converting them from casual to part-time, so offering them that Monday and Wednesday shift on a part-time basis. Now, sometimes that employee might decide that that's not for them because casual, they actually get paid more per hour. But part-time, they get things like annual leave and sick leave and all that accruing. So really, it might come down to that personal choice for that employee, sorry, but the obligation is on the employer to offer it. Now, if you've had somebody in your business that's been there for a little while, they've come to expect shifts from you. It's not, ad hoc. It's not random. It's not, every month you sort of putting together a random roster. It is up to you guys as the employers to go to that employee and obtain their view on it in writing. So I always recommend following that up with an email saying, "Hey, Sam, I know that you said that you're happy to continue casual on this basis, or you've opted to convert to part-time. Here's what we're going to do." Mark's got a question. What's the average casual loading? It's usually 25%, Mark. So I'm not the best at maths, but usually people that are sort of motivated more by the money will often, very quickly say, no, I'd prefer to stay casual and have less, I guess, job security. But some people that want the job security or are looking to get their feet under the desk more in your business would probably, would be very interested in doing that part-time. Hope that answers your question. Sorry, I've already added another slide on this, but hopefully this helps emphasize the point. So put a calendar reminder in your calendar to remind yourself to double check in with those casual employees if they are developing a bit of a systematic work pattern with you. Alrighty, so diving into fixed term contracts. Now, these are really, I guess, business specific and they might work for you, they might not. They aren't used as regularly as they used to be, but certainly the laws have changed in this because really you can't just continually put somebody on a fixed term contract. And you can see why, it doesn't give them any ability to sort of have that ongoing employment. And it is, when you're putting things in balance, it is a little bit unfair on behalf of the employee. So you can do a fixed term contract, of course, but if you're looking to put them on another fixed term contract, you should probably have a conversation with a lawyer just to make sure that you're doing it in the right way. Because, you can't be seen to just extend somebody's fixed term contract or have them sign another one on an ongoing basis, when really, in reality, it probably sounds like they're a full-time employee. Yeah, so in terms of it's a really good option when you're covering things like parental leave or extended leave. But certainly there's nuances to it. So earning above the high income threshold and things like that, you really should have a conversation with a lawyer before you do it. Cool. I'll keep flying along. So in terms of pay secrecy, so you may have seen this, it was trending a little bit in the news because employees have the right to basically chat about how much they get paid. There used to be prohibitions on things like, those employees having the ability to do this, but really, I guess the common sense approach there is that, they're human beings and they're allowed to chat amongst themselves, and they probably were doing that anyway. But there used to be the ability to stop that. So I think I'm just moving the webinar chat so I can see the rest of this. I think things are moving in a more transparent way for employees, and things are getting harder for employers, which if you haven't already gathered. So these types of things are really good to be aware of. And, if you do have an internal HR, or you do have internal people and culture and things like that, those types of things are really good to make sure that they're across. I might just keep flying through this one. So there's a high income threshold for people that are earning over $183,000 a year. This changes every year. So each year the government decide what that number is, and that has flow-on effects for tax and things like that. But it does, I guess, eliminate some protections for those employees that are earning above the high income threshold, because I guess the way that the legislators work is that they are earning a higher income, that therefore they potentially are taking on more risk. So there are some changes. Oh, thanks, Joel. There are some changes that have occurred as a result of this. And more often than not, they may not be covered by a modern award. They're often not covered by unfair dismissal protections, which there might be a slide about this a bit later. And there's, more ability for an employer to have more, I guess, control over that employee. So that type of control might be around their ability to go and work for a competitor after they leave. It might be about soliciting their clients and customers and things like that. So really have regard to how much you are paying your employees, and making sure that if anyone tips over that threshold, they should be treated differently from a management perspective, because different things apply to them. Okay, great time to ask any questions. Feel free to flick them through, but we might dive into common hiring mistakes that I often see day to day, if we are happy to keep going. Yeah, so I think it goes without saying, having a contract, super, super important. And in this day and age with templates and Lawpath AI and things like that, it really shouldn't be the case that you've got anyone on the books hasn't signed a written contract. Misclassifying your staff. So as I said, if you're ever unsure, you really shouldn't be sham contracting, which is engaging a contractor in every way, shape, and form that actually should be an employee. More than happy to have a chat about that, because that's probably the most common thing that comes up with everyone. Underpaying or using the wrong award, forgetting your super, forgetting their entitlements, and skipping actually onboarding. I know with small businesses, things move really quickly, and oftentimes you want them to get on the tools really quickly and I guess start earning revenue for your business. But that onboarding piece is super important. Really, what you want to be able to do is hand over a beautiful handbook that's got all your policies and procedures in there. And what you'd like that employee to do is tick off or sign off and date exactly when they've reviewed that. So then there's less of an obligation on you to make sure that you've gone through every single policy and procedure with them, and frees you up to do the onboarding of your specific stuff, and then puts a bit more of the onus on them to learn exactly how they need to do things in your business. Okay, some of the policies and procedures that are probably the most required or prudent: discrimination policy, sexual and workplace harassment and bullying. Now, these are the types of things that we see all the time that attract attention, and attention is probably not something that we want for this. We want to have attention for, going viral with a cool new product or things like that. We don't want any type of discrimination, harassment, any, that sort of stuff in your workplace, because that can do serious reputational damage. So those types of policies and procedures are an absolute fundamental. In terms of IT use, and things like privacy and surveillance and things like that, that's becoming more and more important in this day and age. With hacks and people making sure that if you are collecting data and things like that, making sure that your employees are using it safely. Social media policies, working from home policies, this comes up all the time, and health and safety. So, even just going down to how to set up an ergonomic chair from home, those types of things. Can we incorporate policies and procedure handbooks into contractors' contract by reference? Now, you can, but they need to be specific to them being a contractor, because ultimately, if somebody looks and feels like an employee based on the way they need to act in accordance with your policies, it might point further towards an employment relationship. So in terms of policies and procedures, they do need to be geared towards employees and contractors, and it needs to be quite clear what the expectation is for both. Great questions, Mark, by the way. Okay, I touched on this one before, and this is coming up all the time if you haven't seen of late, because a lot of laws have changed in terms of non-compete and non-solicitation clauses. Now, non-compete means that you be restricting any employee that works with you from going to work for a similar business after they leave. The best way to do that is making sure that they have, it's limited in terms of geographic area, being quite specific about what a competitor is. You might actually list out the specific competitors. And in terms of non-solicitation clauses, it's stopping them stealing your clients or your team. You might have your whole marketing team try and leave or something like that. So if you're able to point to a contract that stops them doing that, that's really helpful for you. Now, a great question is, are they enforceable? Oftentimes, the answer is no, because they're not specific enough and they're not reasonable enough to prevent that employee from going to earn a wage elsewhere. So really, it does come down to specific circumstance with this. It also comes down to how much they're earning, and it also comes down to their award that they're under, because the changes that came in a couple of months ago in terms of non-competes and non-solicitations haven't come into effect right now, but they will. They're coming this coming year. So anyone under the high income threshold, it's going to be very hard to impose a non-compete and non-solicitation on them. Alrighty, I'll keep skipping through. I mentioned before the right to disconnect. So in terms of this has been in place for a while, but it's always good to keep front of mind. And, a lot of businesses in this day and age are working on things like Teams and Slack or, WhatsApp and things like that. And it does really make it hard for that employee to disconnect. And there's a legal right now for them to be able to. So really, that should be put in a policy in your business to make sure that you outwardly are showing that you are committed to that. And I think it is really, as business owners or managers, depending on what role you're in, really, really important there to make sure that you are abiding by that one. So I think it out of all the laws that I've referenced here, this is something that you should have a look at and go back and double check and make sure that your business practices work for that. And I guess as laws and legislators love to do, it always comes down to the reasonableness test. So in terms of the reasonableness for the right to disconnect, it is assessed on a case-by-case basis. It comes down to seniority, pay level, urgency, and business needs. So those types of things are, come down to the reasonableness test. And if you're ever unsure, it's good to have a conversation with a third party, lay out all the facts, and that third party, if that being a lawyer or somebody that you know and trust, that they can often help you make a decision about what's fair. Okay, I've spoken a lot. There's a couple of takeaways that we will dive into, but I think the key things are contracts in writing and be really confident about what you've actually got in writing. A question I'm often asked is, can I change a contract once somebody has been employed by me? And the answer is yes. It does need to be agreed by the employee, the new contract. But if you're thinking, do you know what, I need to overhaul these and get everyone on an improved contract, you can do that. Knowing your obligations. So understanding what awards your employees are coming under, the NES entitlements, and any Fair Work updates. Something I like to do is put a Google alert in Fair Work updates for awards that I'm particularly working in, and you do see those updates come through. But as a rule of thumb, it's about once a year that they're changed. Staying up to date, that's the hard thing because we're all running businesses and we're all busy. So I think the key thing there is diarize those things to remind yourself as a business owner to double check those legal requirements on a regular basis, because then it flows into this protect your business, because that's going to help you avoid those fines, disputes, any back pay claims and things like that. And as I've mentioned throughout, the lawyers at Lawpath, but also elsewhere, they're happy to talk about this stuff because these things happen all the time, and you're not alone. And we're here to help, and we love to help. So always ask for help instead of just flying blind, because as I said, these things are really hard. So how Lawpath can help. I'm going to hand back over to Joel, but feel free to put any other questions you have in the chat.
Thank you so much, Liv. How's everyone doing at this point in time? They feel like they're learning something, or is there still some questions that they need to ask they feel like needs to be fleshed out? How are we feeling?
James has got a good question.
Yeah.
I'm happy to answer that one quickly now. A little bit off topic, James, and I'm happy to have a separate conversation with you about this, but a lot of people are sole directors and pay themselves a salary. Is it legally required that you get workers' comp insurance? It really is situationally dependent, but in this circumstance, just reading off these facts, oftentimes workers' compensation claims need to be verified by somebody else in the business. So if you hurt your back, for example, very unlikely that you're going to get a workers' compensation payout because you're the only witness there at your workplace. So it depends on the situation, but if it's just you, no, the answer is no.
Brilliant. Thank you, James. So, guys, excuse me, maybe I should get some water as well. What my role here at Lawpath is to do is to consult. So you can imagine I'm in the trenches every day dealing with clients who are both pre-existing or just coming in. And what I can tell you is one of the biggest issues that we're finding with a lot of people is usually around employment. So if you are at the stage with your business where it's time to take on employees, that's a positive indication that things are working. It means you're expanding your brand and operations, and now it's time to take on some help. So if you guys are attending this webinar because of that reason, congratulations. That's absolutely brilliant. It can be difficult, however, when you are a new business owner to not see everything as numbers. All day, every day, you're conscious of cost and time and resources expended, et cetera, all numbers. And when taking on employees, it's possible to put new staff members into that just a number category instead of identifying them as human beings with feelings and emotions. I mean, we've all worked for someone else at some point. We know when you're working for someone who just does not care about you. I don't think there's a single human being on this planet who's ever not experienced that. And at times, especially for this webinar, it does sound silly to mention that kind of categorizing humans as numbers. But you'd be surprised with some of the conversations I've had with clients who are under attack by Fair Work in particular. I didn't know too much about Fair Work until before I joined Lawpath years ago, and I've found that Fair Work they are the real boogeyman. So believe me, not everyone is as considerate as you guys, and I'd like to consider you're all considerate, seeing as you're coming here to educate yourselves. So with this in mind, having the right support to go over the development and review of employee and contractor agreements should be a necessity, especially if your business is reaching a growth stage and you wish to keep the ball rolling smoothly. And keeping with the theme of being a busy business owner, you won't always be able to adhere to specific times to get advice from a lawyer, for example. Lawyers are busy, you're busy. It's waves and waves and channels. So the beautiful thing about Lawpath's legal advice plan means you can book a same day or next day consultation with your dedicated lawyer to get immediate advice or action something that's got essentially a deadline. Here at Lawpath, we want you to be comfortable. We want you to be confident. We want you to feel no friction in your day-to-day operations in relation to compliance. The 20% is you just building out the brand and working. The 80% is that yucky friction. And this is where we want to assist you so this just becomes irrelevant in your day-to-day. So with our plans, for those who are new, one of our main plans is the legal advice plan. This essentially gives you unlimited 30-minute consultations with a senior lawyer every day. So Monday to Friday for 12 months, whenever you decide, you can choose whom you wish to collaborate with every day. So that will be your ongoing lawyer. I know it would be an issue if I was a business owner and I had to speak to someone new each time to, I guess, tell my whole life story to. Would be quite frustrating. So you can choose who among the team you find works best for your business, and bring them on board as your go-to lawyer. Now, not just employment, we also deal with commercial, HR, property, debt recovery. There's a plethora of things that are covered within the legal advice plan. And if you do wish to obviously get assistance with employment, but also have maybe previous contracts that you're running a business under reviewed, or if you have future plans to expand out of the state, again, take on employees, or just general document review for anything big, well, naturally the legal advice plan can assist that. And obviously, we also have a quoting system for something that might be a bit more severe. So if you do have, if you do prefer just a one-off approach to getting legal advice, having a document drafted, or some specific information discussed, there is also a quoting system that I will mention within the email. Adjacent to the legal advice plan is also our essentials plan. If you are someone who deems that their knowledge is sufficient and they don't necessarily need a lawyer to review anything that they've got going on, and you're happy to just work on documents autonomously, employee agreements, HR related, contracting, etc., you can benefit from our essentials plan. But all of our plans are two options of payment. It's yearly or quarterly. As you can see here with the essentials plan, you get unlimited access to over 550 plus legal documents. There's no Lawpath watermarks, so they'll be yours. You can edit them at your whim, remove, add, whatever it may be. Add your own logo to the top of it. You also have access to e-sign as well. So if you are taking on employees, and you wish for them to sign contracts before they come in, naturally it might be easier if you are busy to have to scramble around and get a printer and print out some documents and have them sign it beforehand. That can always be very frustrating. And for anyone who is asking in relation to the other side of employment, which is your accounting, doing your invoicing, payroll, et cetera, we also have an accounting advice plan. So the accounting advice plan is operated almost identical to the legal, unlimited 30-minute consultations with the senior chartered accountant. Now, this is a lot of people tend to see the bookkeeping aspect and think we will do their bookkeeping. Not at all. We will set you up with an accountant. And if you are in the early stages of owning a business, it may not be necessary to actually have a bookkeeper doing all the work for you. We always like to advise to at least know your books, know how to do your own bookkeeping, at least in the first 1 to 3 years. And a good way to save money and not have to field the queen on the chessboard to do a pawn's work, essentially, is to hop on the accounting advice plan, unlimited 30-minute calls. We will set you up on either Xero or MyOb or any other kind of accounting software that you prefer. Our accountants are very adaptable, so they will learn with what you prefer to use. And they will teach you through these systems how to do your own bookkeeping, do your own payroll, inputting invoices and anything like that. If there's certain things you wish to invest in, you want to know, do you have the right amount of money? Can you keep your head above water if you do hire your first employee, et cetera, et cetera? All of this is covered on that plan as well. And it's a wonderful thing to be able to just maybe call your accountant at the start of the week and at the end of the week and have them look at what you're doing to make sure all your books are clean and in order. We can advise on BAS as well. So when it does come time to do your BAS and tax, if you have a dedicated tax agent, all your books will be clean and in order, and they won't charge you as much because obviously we've assisted you in making that neat. Or if you just flat out don't have a tax agent, you want a solid business-based tax agent who's going to really take an in-depth look at how well you did last year or last quarter and advise you on where you're doing well and where you're not, and have those nitty-gritty conversations with you. We also have a tax plan as well. With each plan, you can purchase them individually or you can bundle them together, and we usually slap a 40% off discount on top of that. So a lot of really good options for anyone who's starting out and they just want that solid support. And look, that should be everything from me. If anyone has any desire to have a further conversation, just a general chat around what your plans are in the future or what we might be able to offer you now, feel free to go ahead and throw yes down in the chat box, and I'll take your name down and I'll make sure to contact you directly afterwards so we can get a bit of a discourse going.